All right, you're welcome back, and let's see what we make of a few of the developments that are coming up as far as the judgment debt issues are concerned, and the white paper that was issued, and lawyer Kwame Akufu is on the line. He is bringing an aspect that it didn't occur to most of you and all of us as far as we did the debate and the discussion was concerned. But before that, let me just read this one from Suhini, who has also won the elections. He says, it is only bias that will prompt the pro-MPP media to celebrate election of a 26 or 28-year-old girl in the MPP primaries, but question the experience and competence of over 29-year-old winners in the NDC primaries. Okay, so he's referring to, you remember that very young lady, who won the elections in the primaries in the NPP and was celebrated all over. And he's saying that for those questioning, those in the NDC who have won, who are 9 years or more, it is only propaganda for such a thing to be done. Thanks for sending in your message. Congratulations. Anyway.
But has anybody said anything like that on this platform?
Well,
I don't think that
okay.
So
all sorts of things happening.
Anyway,
okay, quickly. We have very limited time.
You're not restricted to this.
Thank you. This show is brought to you by Bank of Africa, strong as a group and close as a partner. MTN, welcome to the new world. Sasso Spray, fresh and powerful. Star Assurance, creating smiles since 1985 and celebrating 30 years of solid partnership. Lipton Tea, the #1 tea brand, and Yumvita. It is your delicious way to grow. Lawyer Kwame Akufu, good afternoon, morning. Thank you for joining us on Newsfile.
Good morning. Thank you for having me, and good morning to your panelists.
Great.
Good morning, Kwame.
Now there's an intriguing aspect that you raise about the judgment debt findings, particularly in respect of the GMPC, Societe Generale versus GMPC matter. You suggest that the defense that is alleged to have been filed, the defense that is alleged to have been there, which if Nanado had pursued, would not have brought us to the debt. We have questions to answer in that regard. What are the questions you raise?
Let me go straight to the point, and it's fundamental. If you look at the Judgment Debt Commission's report, it takes the position that on the day that an application for discovery was to be heard, Akufo-Addo did not take steps to ensure that there was an appearance on behalf of the Republic in court, and therefore the application was struck out. Subsequently, the court then entered an ex parte default judgment against the Republic. The question which has to be asked by all of us is that if there was a statement of claim and a statement of defense and a counterclaim on behalf of the Republic, how was it then that an ex parte default judgment was taken? Because in all the jurisdictions, the common law jurisdictions, even in the United Kingdom, when you have a statement of defense on the record and a counterclaim, and you don't appear in court, it is nigh impossible for a party to take an ex parte application in default of something, defense or appearance against you. Above all, the Commission never scrutinized or examined the alleged statement of defense and counterclaim which was placed on the record. So it makes the Commission's findings on that matter rather tedious and weak.
Okay, your point of law is that in law and within the Commonwealth jurisdiction where we also practice, it cannot happen that for as long as there was a defense on the record, there could not have been a judgment in default as happened in this case, right?
Absolutely. That's the position I take. Because, Samson, if you file a statement of defense and you don't attend court, the judge may ask you to proceed to trial. If you read the Judgment Debt Commissioner's report, he says that because the application for discovery was struck out due to the absence of counsel, the party then proceeded to enter judgment surreptitiously against the Republic. When the English court fixes a date for a hearing, there is a schedule. There is an agenda for that day. It cannot be that merely because a party is not present in court, the agenda for the court hearing will subsequently change and an ex parte application for judgment in default will take place. Because the discovery proceedings are completely different. You need the discovery to aid your defense. If you don't turn up for discovery, the judge may well proceed to have directions or issues set down and the mode and case management processes set down, and then you proceed to trial.
So bottom line, your claim, bottom line.
I don't believe we ever had a statement of defense.
Bottom line, your point is that it cannot be true what Mr. Chachuchikata represented before the commission.
Let me put it this way as a lawyer should speak. It is not probable that we have a statement of defense and counterclaim on the record. It is not probable. On the record before the commission, on the record available to the citizenry, it does not look probable that we have a statement of defense and a counterclaim. You look at the Judgment Debt Commission report. He starts, if I could just conclude here.
Yeah.
For example, he says that it was at the point in time the parties have almost agreed at $40 million.
Right.
Then without any connection, he comes to the conclusion that the parties had agreed on $40 million. It is that same error that motivates the commissioner to come to the conclusion that it was a statement of defense and counterclaim when none was ever presented before the commission. That's my humble submission on this issue.
So you're saying that Mr. Chikata and his team should not be heard to say that they were actually defending the case and that it is Nanado's failure to continue with that defense that led to this debt and the cause of financial loss.
Let me speak to you as a lawyer should speak, because I have to speak to you as a lawyer. I'm saying that on the available evidence before us, there is nothing to show that there was a statement of defense on the record. There's no evidence to show. I don't like to use the word untruth, falsehood when it comes to intellectual debate, because somebody could produce the document someday. But as we speak today in this republic, nobody has cited that document, and therefore the commission could not have arrived at that conclusion. The conclusion is without foundation.
So what should the commission have done?
The commission should have asked at least to examine that statement of defense. The commission should at least have asked to examine that statement of the counterclaim, because everything was up in issue, especially since Nana Akufo-Addo was never invited before the commission, and that position had been asserted against him. It was only feasible, proper, healthy, and necessary that those documents be examined for the commission to reach a healthy and properly balanced, focused conclusion.
Okay. Thank you very much for your time and for sharing your insight with us.
Thank you.
Now, okay, straightforward. Let me find out from you, Egbert. What the angle he brings to this discussion? It throws the commission in a certain light that may not be too good.
Yeah, it is a very refreshing.
Because the commission has a heavy reliance on the claim by Mr. Chikata that there was a defense.
Yeah.
And Nanado's failure to pursue that defense led us to the debt.
It is a very refreshing viewpoint that my friend Kwame Akufo has brought. And I think that we need to even put it in perspective by quoting from the white paper.
All right.
Page 12 thereof. Let's say paragraph 7, 2. It says, a dispute arose and Societe Generale sued GMPC in a London High Court over payments that Societe Generale alleged GMPC owed it. Then you go to 7.3. It says GMPC denied the claim and counterclaimed against Societe Generale through its external lawyers, Vindman and Partners, for negligent advice by Societe Generale. You go to page 13. Here, paragraph, this should be 6.7. The London High Court entered a default judgment against GMPC for $47 million in June 2001. Samson, you and I are lawyers, and also all lawyers listening to us. There are only two types of default judgments, at least in this Ghanaian jurisdiction,
right,
which we
it's
receive. Yes,
yeah.
You can enter, a court can enter judgment in default of appearance, or a judgment in default of defense. In this instance, we are told by the commission that GMPC filed a defense and counterclaim. It's one document. So how can the same London court, in the face of the existence of a GMPC defense and counterclaim on its record, turn around and say you didn't file a defense, so I'm entering a default judgment against you?
Okay, possibility. What would be the possibility?
I'm not a lawyer. We need to know.
I thank God you are not.
Was there a withdrawal at a certain stage when they dispensed?
Withdrawal of the defense.
They dispensed with the service of the firm that GMPC had procured. But,
so the commission ought to be telling us whether the said defense was filed and withdrawn.
Samson, it's unfortunate that we are opening a discussion on the judgment that I commissions, I report, and the white paper with the albatross or the seeming albatross around the neck of Nana Akufo-Addo with regards to IDs.
Because it's very important, it's very critical.
I think that if you want to look at some of these things that are critical also, then you may want to avert your mind to the issue under Delta Foods, and perhaps Kwame Akufu may come
Delta
again.
Foods is
if you go to Delta Foods,
I've read it, but
where they are making reference to the Attorney General, Honorable Nana Akufo-Addo, advised a payment of the amount demanded to the solicitor of Delta Foods Unlimited, Honorable Peter Lajete, and the commission concludes that the $4.9 million constituted a huge financial loss to the state.
Right.
But I sincerely think that, look, these are steps that even if the commission did not exhaust, okay, nothing stops anyone from ascertaining the details in there. Let's face it, the commission had only a period to act. They couldn't have been sitting for 2 years, for 3 years, and all. That aside, for me, our attitude to this Judgment Debt Commission's report and the white paper thereof should not be about defending Nana Akufo-Addo, KT Hammond, Woyome, or whatever, particularly as we have serious issues where even institutionally, people that the courts themselves were relying on, sometimes to do some calculations for them and all, have been identified to have done very terrible things, and there's a recommendation that one of them should be blacklisted. We have a situation where
the recommendation that entity should be blacklisted.
We have
which entity should be blacklisted?
I've forgotten its name. This gentleman.
Is it
Ben Colley.
When adverse findings are made against a person in a commission of inquiry reports, that adverse findings, pursuant to the Constitution, becomes a judgment of the High Court, appealable.
Okay.
When those processes crystallize.
6 months.
Yes, and so if you say somebody should be blacklisted, are you saying this pursuant to the person's rights to go to the court of appeal?
So if that's what states.
That is only consequential.
Okay. Yes.
Is that why?
And Egbert makes the same mistake.
Please.
When he deals with about the $1.3 million dollars, which is unaccounted for as we speak now, in respect of the drillship sale.
Yes.
He makes the same mistake.
I don't make any mistake.
So the point I'm making is
what mistake? Mention the mistake.
The mistake you make is that Yoko cannot look into that $1.3 million US dollars that has not been accounted for. Just because the commission has sat on the issue of Societe Generale versus GMPC. And I say that is overstretching the frontiers.
Please, let me answer you there. Let me answer you there. You see, this government seems to be laboring under a certain illusion. And I'm going to quote for you CI 65, Commissions of Inquiry, Practice and Procedure Rules 2010. If you go to Regulation 13 thereof, it says a witness appearing before a commission is entitled to the same privileges to which a witness before the High Court is entitled. Samson, those people who appeared before the commission, they went to speak, am I correct, as witnesses, am I correct? So in the light of Regulation 13 of CI 65, and also look at Article 283 of the 1992 Constitution, apart from it being enshrined in this law, it is also giving a constitutional stamp. Look at Article 283. So if you want to deal with people, don't set up commissions of inquiry. Because when a person has spoken, you cannot use what the person has said at the commission to instruct Yoko, the police, or anybody. You are not a lawyer. You make this mistake.
It is not
and you want to dabble in law. Please stay with your medicine and propaganda. It will help
the white paper was not drafted by a medical doctor.
Please.
Let's note this. It was not drafted by a medical doctor.
You are reading from it.
Egbert makes the same mistake.
Please.
And
I don't make any mistake.
And the mistake is expressed from his subconscious. Per the statement that he has made, that if you want to deal with people, President Mohammed's government is not interested in dealing with people.
Martinamidu says that's what you are up to with the
White House. The least said about Martinamidu, the better. You can. Yes.
He's a leading MPP propagandist.
The least said about the least. Can you say
listen? Let us not mince words.
Martinamidu said about Anas.
Don't bring Anas into this matter.
What hasn't Martinamidu said about Anas? In the case of Anas,
party, be cautious.
In the case of
a senior member of your party.
I'm saying that the least said about him, the better, and that is how
your quest to
charitable.
do mischief, you are
So it's okay. Can we end this here and then you proceed briefly on the other
Please,
areas?
I want
you
to withdraw on your behalf what you said about Mr. Martinamidu.
I will not.
I think you are sorry for it.
I'm saying no, please.
Oh, you want to escalate it?
If he's serving your purpose,
he's
a hero.
He's my senior at the bar. He's my senior at the bar. I respect him.
Can we proceed to deal with
leave Tiger out of this? Just stay out of legal issues.
It is all part of the ecosystem.
You stay out of
we are
legal
discussing
issues
today.
Right.
My
Ecology.
brother,
What ecology?
it is part of the ecosystem.
We are running out of time, gentlemen.
So ask Egbert
Stay with medicine
to be a
and
bit
propaganda.
disciplined about the discussion we are having. My brother, I'm saying that President Mahama is not out there to deal with people, quote and unquote, as Egbert wants us to believe.
But that's
President
what
Mahama is looking at, one, strengthening institutions. That is very important. And by the issues that I have raised, even to the point where you had a whole general legal council, and if you look at this white paper, the mess.
General Legal Council is the body that regulates law practice in Ghana and legal education.
Fantastic. And I'm not referring to this particular General Legal Council. Let's be fair. The conduct of that General Legal Council around 2003 and thereabout, which led to a certain judgment debt, that in itself should let you know the extent of.
What is he talking about?
There's a bit about the law school.
Yes. Go and read the entire.
I have read it,
report.
but be specific.
Go and read
you
the entire.
You are broadcasting to the public. You cannot be talking in parables.
Let me refer.
It was on the dismissal of the registrar.
Yes, let me refer you to it specifically. Mr. Asasari at that time was there and all. Good. So if you can have the General Legal Council getting itself into that kind of situation, if you can find someone that the courts have been relying on to do some of these calculations for them, also misinterpreting laws, legislations, and all that in the manner that it was done. If you can find surveyors saying that they sat on a boat and on the water, the families were directing them to, this was the boundary. On water, that was the boundary, and that was the basis for they determining the acreage that warranted compensation payment. You can only say that, look, the recommendations contained in this white paper must be followed through. The next one has to do with monies that can also be retrieved. And let me draw a clear picture here. You realize that the Commission's position on the Alfred Woyome case has to do with the fact that the payment has to be with interest. In the white paper, government accepts this white paper. Again, you go to areas like Rockshell, CP, and all. At this stage, I think that rather than the NPP being defensive about what Nana Addo did or didn't do, they must look at the white paper in its totality, and let's all know that it is not true that the MPP or Nana Addo as an Attorney General defended every case, and that there were certain cases that even settlement had to prevail and all. I'm not by this saying that the Attorney General's department, not now, but even previously, has been saints in terms of the way that they have handled issues. But my brother, I have about 11 cases cited here which demonstrate clearly a departure from the norm. The norm being the kinds of things that led to judgment debt and payments and all that. That this present Attorney General's department is pushing strongly. You can talk about sweater and socks. You can talk about the Palmot holding. You can talk about the TJGM case and all that. About 11 cases in which the current Attorney General has contested vigorously and has been successful in saving the state millions of Ghana cedis in some cases and millions of dollars in other cases. Let no one be overly defensive about the things that have happened in the past. That is what I would say.
Okay.
Institutional strengthening is key.
Right.
going after the people who have committed these things.
And follow the law. It will help you.
Right.
And your government.
Thank you very
Stop
much. And once
propaganda.
again, because we have just run out of time, let me hear Kwekutu on what you want to speak to briefly on the judgment debt issues, and then we'll move on.
We really are.
There's no time to do justice.
So difficult.
Last week, this is what happened, and we decided that we'll continue the judgment debt today. Unfortunately,
because the Delta foods, I have something to say, but it's such that even the time you give me,
you can't summarize.
No.
5 minutes.
So I will wait.
1 minute of that. I have 4 minutes of that.
I will wait. I will wait. I think we'll get another opportunity, either here
The
or
same
elsewhere.
panel can come back next
Let
week.
me go back to the default judgment thing.
Yeah.
You recall I made a point about whether the commission had the benefit of
The documents.
which I think it didn't have. But this is a new angle. But I still am not well educated on these legal things. It's such a striking development for me. But I want to be educated. Fortunately, we have 2 good lawyers here. And then Kwame may be listening. This is the judgment, dated 6 June 2001. Now, I would want to read, very short.
Okay.
Dated this, it says, and upon the defendant having failed to comply with the order of Mr. Justice Thomas, dated 5th June 2001, and the defendant's amended points of defense and counterclaim having been struck out pursuant to the said order, and upon the claimant having abandoned its claims under paragraphs 3, 4, and 6 of the prior to the amended points of claim, it is this day adjudged that the defendant do pay the sum of $40.8 million dollars, or such sterling equivalent as at the time of payment, together with interest to be assessed and cost to be the subject of a detailed assessment. This was sent to Weinman and Partners by Norton Ross.
Okay.
Solicitors to the claimant. Now you are the lawyers. Educate me here. Does this not indicate certain processes?
Yes, it does.
Settlement.
I just don't want to. I don't
Settlement.
understand
It means that the parties spoke and went back to the courts and said, look, we want to settle, and so the defendant is going to withdraw its defense.
And it was struck out as withdrawn.
As withdrawn. And then the plaintiffs will also abandon some of their claims against GMPC.
So how do we reconcile that with a new angle?
Good.
Kwame
Akufu himself left it open when Samson wanted definite answers. No, I'm coming. I'm coming. Now, what then happens is that is it right for the commissioner, the sole commissioner, to say that GMPC filed a defense and counterclaim?
Which was not defended.
Which was not defended.
And on the basis of that,
you should have gone for it to say that based on this document you are quoting from, certain compromises were made. You understand? But the impression created in the white paper based on the commission's report is that GMPC filed a defense and yet still...
is this an ex parte judgment in the true sense of the word?
It cannot be ex parte, or even if it is ex parte, it is procedurally correct.
All right.
But
all right. Okay, gentlemen. There's a critical point. When Kweku spoke about the issue of the and also got all of us supported that Senator Rawlings will have to now. It is when she's about to contest the elections itself that there will be a problem. The NDC's own regulations are being brought to my attention that the regulations say that if a person fails to meet the requirement for the election of a member of parliament under Article 94 of the Constitution, then it is grounds for disqualification of that person for the primaries. So it means that she should not have been qualified pass for the primaries in the first place. Oh, you can waive it. Okay. All right. All right. Okay.
This is a party of unity.
All right. Okay. Sorry, we are running out of time. We are running out of time, unfortunately. My guests have been Kweku Bako.
It doesn't appear this was confidently.
By Latida. Thank you very much. Have a good afternoon.